In Kentucky, a Christian school and the state's attorney general are asking the Supreme Court to intervene and allow in-person classes for grades K through 12 at faith-based schools. Danville Christian Academy and Kentucky Attorney General Daniel Cameron argue that the state's Democratic governor has treated religious schools less favorably than secular gatherings. Roger Byron, senior counsel at First Liberty Institute, joins me now on Skype. First Liberty is representing Danville Christian Academy in the lawsuit. Roger, welcome to the show. Thanks so much for coming on. Let's talk a little bit more about what's going on there in Kentucky. As I understand, back in November, the governor ordered all schools K through 12, including Danville Christian Academy, to halt in-person classes, yet allowed preschools as well as colleges and universities to stay open for in-person instruction. Where do things stand right now?
No, that's exactly right. The First Amendment, to give a little background, requires governments generally to treat religious gatherings with the same favor that it treats any other gatherings. And in the COVID-19 context, it means that a government can almost never place a restriction on a religious gathering that doesn't place on other gatherings. And other gatherings are things like going to the movies, going to work, whether in an office or a factory, or attending a wedding. But in Kentucky, almost everything is allowed to be in person, except that, as you've said, K through 12 religious schools have been closed.
Yeah, and I want to talk a little bit more about your client, Danville Christian Academy. What steps have they taken to ensure the safety of their students, and how is all this affecting them?
Well, Danville Christian is first and foremost a religious organization. Their primary mission is to help its students grow closer to Jesus Christ. And Danville Christian has a sincere belief that in order to do that, it must provide a communal, in-person environment for its students.
I know that you've asked the Supreme Court to intervene. Can you update us on that?
Certainly. We've filed an emergency application with the U.S. Supreme Court, and we're currently waiting on a response from the governor's office, and we hope to get a decision very soon.
And Roger, what do you think is at stake here in terms of religious freedom?
Well, anytime you have the First Amendment challenged or First Amendment rights challenged, the First Amendment becomes weaker unless the First Amendment is enforced, just a little weaker every time. And in this instance, currently in Kentucky, a group of people can go out to a wedding together. They could go to the gym and work out together. They could attend a basketball game at the University of Kentucky together with thousands of other people. They could even go out and get a tattoo, or they could go to the indoor gambling slots at the horse tracks. They are not allowed to gather in person at a private religious school for a Bible class. That is not in keeping with the First Amendment. That does not meet the requirements of the First Amendment.
Well, Roger, we do hope that you keep us posted on the case. Roger Byron, senior counsel at First Liberty Institute, thank you so much for your time, sir.
Thank you.